Hello everyone, welcome to the channel Target for IQ. This is Shikha Singh, and in today's video I am going to discuss a few MCQs on the subject Indian Contract Act 1872, which are going to be really helpful for your upcoming judicial services examination, and there are highly chances that these questions might be asked. So let's begin. First question is, in India, past consideration is good consideration. This is the result of the provision of which section? Options are A. Section 2D, B. Section 23, C. Section 25, subsection 2, D. Section 25, subsection 3. So, the correct answer is A. Section 2D. Next question. Quid pro quo means? Options are A. Meeting of minds, B. To do something, C. Something in return, D. Promise. The answer is C, something in return. Next question. A proposal can be revoked. A. Before posting of letter of acceptance by the acceptor. B. Before receiving the letter of acceptance by the offerer. C. After posting of letter of acceptance by the acceptor. D. Cannot be revoked. So the correct answer is A. Before posting of letter of acceptance by the acceptor. Next question. An agreement in restraint of the marriage of any person other than a minor is A. Void, B. Voidable, C. A contingent agreement, D. None of the above. So the correct answer is A. Void. An agreement in restraint of the marriage of any person other than a minor is void. Next question. Active concealment of fact is associated with which of the following? Options are A. Misrepresentation, B. Undue influence, C. Fraud, D. Mistake. So the correct answer is C. Fraud. Next question. The word consensus ad idem means. The options are A. No agreement can have more than one meaning, B. To agree in the same way, C. To agree on the same thing in the same sense, D. To agree for different objects in the same sense. So the correct answer is C. To agree on the same thing in the same sense. So the words consensus ad idem means to agree on the same thing in the same sense. Next question. In which section it has been stated that contingent contract based on impossible event is void? Section 56, Section 36, Section 31, Section 30. So the correct answer is B. Section 36. Next question. When the damages cannot be assessed, the party may be awarded by the court. A. Actual damages, B. Liquidated damages, C. Exemplary damages, D. Nominal damages. So the correct answer is exemplary damages. Next question. When a person to whom proposal is made signifies his assent thereto, the proposal is said to be. The options are A. Invitation to proposal, B. Promise, C. Agreement, D. Acceptance. So the correct answer is D. Acceptance. When a person to whom proposal is made signifies his assent thereto, the proposal is said to be acceptance. Next question. A notice in the newspaper inviting tender is A. A proposal, B. A promise, C. An invitation to proposal, D. None of the above. So the answer is an invitation to proposal, which is C. Next question. A contracts to pay B rupees 1,000 if B's house is burnt. This is. The options are A. Void agreement, B. Wage contract, C. Contingent contract, D. Quasi contract. So it is C. The correct answer is C. Contingent contract. Next question. The age of majority for the purpose of the Indian Contract Act 1872 is A. 18 years for girls and 21 years for boys, B. 16 years for girls and 18 years for boys, C. 21 years, D. 18 years. So the correct answer is C. The age of majority for the purpose of Indian Contract Act 1872 is 21 years. Next question is, which of the following cases is related to the doctrine of frustration? The options are A. Headley versus Baxendale, B. Carlyle versus Kabolik, C. Smokeball Company Lalman Shukla versus Gauri Dutt, D. Satyabrat Ghosh versus Mugniram. So the correct answer is D. Satyabrata Ghosh versus Mugniram. Next question. The principle of assessment of damages for breach is given in A. Headley versus Baxendale, B. Scorff versus Zodine, C. King versus Hoare, D. Hyde versus Wrench. So the correct answer is A. Headley versus Baxendale. The principle of assessment of damages for breach is given in Headley versus Baxendale. Next question. A wagering agreement depends on A. An uncertain event, B. Future event only, C. Past uncertain event only, D. None of the above. So the correct answer is A. An uncertain event. A wagering agreement depends on an uncertain event. Next question. A promise to pay a debt barred by the law of limitation has been made enforceable under which section of the Indian Contract Act? Section 32, Section 47, Section 25 or Section 8? The correct answer is Section C, Section 25. A promise to pay a debt barred by the law of limitation has been made enforceable under Section 25. Next question. Which one of the following relations does not come within the undue influence relationship? The options are A. Doctor and patient, B. Customer and shopkeeper, C. Lawyer and client, D. Master and servant. The correct answer is B. Customer and shopkeeper. So this customer and shopkeeper relation doesn't come within the undue influence relationship. Next question. A contracts to sing for B at a concert and gets ₹1,000 as advance. A is too ill to sing. Here, A is bound to sing. B, A is bound to compensate B for loss. C, A is bound to return the amount of advance. D, none of the above. So the correct answer is C. A is bound to return the amount of advance to B. Next question. Minor's contract is A. Void, B. Voidable, C. Void at the option of minor, D. Valid at the option of the minor. The correct answer is A. Minor's contract is void. Next question. What is a reasonable time for performance of a contract? The options are A is a question of fact, B is a question of law, C is a question of fact and law, D is a question of prudence. So the correct answer is A is a question of fact. Reasonable time for performance of a contract is a question of fact. Next question. A counter offer is A. An invitation to treat, B. A bargain, C. An acceptance of the offer, D. A rejection of the original offer. So the correct answer is D. A rejection of the original offer. Next question. What contract is created between a finder of lost goods and its true owner? A. A contingent contract, B. A quasi contract, C. Wagering contract, D. A contract of guarantee. So the answer is B. A quasi contract. Next question. Threat to strike is A. Undue influence, B. Mistake, C. Coercion, D. No coercion. It is D. The answer is D. No coercion. Threat to strike is no coercion. Next question is an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other. The options are A is a void contract, B is an illegal contract, C is a voidable contract, D is an unenforceable agreement. So it's C is a voidable contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of others, is a voidable contract. Next question. The very first known case related to the doctrine of privity of contract is A. Tweddle versus Atkinson, B. Dunlop Pneumatic Tire Company versus Selfridge and Company, C. Dutton versus Poole, D. Jamna Das versus Ram Avatar. So its correct answer is Dutton versus Poole. Next question. Which of the following cases deals with promissory estoppel? A. Durga Prasad versus Baldev, B. Kedarnath versus Gori Mohammed, C. Tweddle versus Atkinson, D. Dunlop Pneumatic Tire Company versus Selfridge. The answer is B. Kedarnath versus Gori Mohammed. Next question. An agreement made without consideration is A. Void, B. Voidable, C. Not valid, D. None of the above. So the answer is an agreement made without consideration is void. Next question is continuing guarantee has been defined under. Options are A. Section 124, B. Section 129, C. Section 146, D. Section 148. The correct answer is B. Section 129. Next question. The interpretation clause of the Indian Contract Act 1872 has been provided in. The options are A. Section 1, B. Section 2, C. Section 3, D. Section 4. So the correct answer is B. Section 2. Next question. Which section prevents unlawful enrichment? The options are A. Section 68, B. Section 69, C. Section 70, D. Section 71. So the correct answer is C. Section 70. Next question. A contract is not frustrated by. The options are A. Commercial impossibility, B. Imposition of government restrictions, C. Destruction of subject matter of contract, D. All of the above. So the correct answer is A. Commercial impossibility. A contract is not frustrated by commercial impossibility. Next question is, a stipulation for increased interest from the date of default is known as A. Damage, B. Penalty, C. Liquidated damages, D. Compensation. The correct answer is B. Penalty. Next question. Koti Jairam versus Vishwanath AIR 1925 Bombay case is related to. Options are A. Section 73, B. Section 56, C. Section 17, D. Section 23. So the correct answer is D. Section 23. Koti Jairam versus Vishwanath case, it is related to Section 23. Next question. An agreement made without free consent is A. Always void, B. Voidable, C. Unlawful, D. Either void or voidable. So the answer is D. Either void or voidable. Next question. When prior to the due date of performance, the promisor absolutely refuses to perform the contract, it is known as A. Abandonment of contract, B. Actual breach of contract, C. Remission of contract, D. Anticipatory breach of contract. So the answer is D. Anticipatory breach of contract. Next question. Damages allowed under Section 73 of the Indian Contract are. The correct answer is B. Compensatory damages. Next question. Unlawful consideration and object have been mentioned under which section of the Indian Contract Act 1872? The options are A. Section 18, B. Section 20, C. Section 26, D. Section 23. So the correct answer is D. Section 23. Next question. Nudum pactum means A. Without consideration, B. Invalid contract, C. Void contract, D. Voidable contract. So the correct answer is A. Nudum pactum means without consideration. Next question is, every promise and every set of promises forming the consideration for each other is called A. Avoidable contract, B. Valid contract, C. A void contract, D. An agreement. So the correct answer is D. An agreement. Next question. The Indian Contract Act 1872 extends to A. The whole of India, B. North India only, C. The whole of India except Northeastern region, D. The whole of India except Union territories. So the correct answer is A. The whole of India. Next question. A. agrees to sell B. all the granary in his granary at Ramnagar. This agreement is A. valid, B. void, C. voidable, D. illegal. So the correct answer is A. valid. This agreement is valid. Question. Rescission of the contract means A. the renewal of original contract, B. cancellation of contract, C. alteration of contract, D. substitution of new contract in place of earlier one. So the correct answer is B. cancellation of contract. Rescission of the contract means cancellation of contract. Next question. A contract and social agreement is that of A. a consideration, B. intention to create legal relationship, C. consensus ad idem, D. certainty of performance. So the correct answer is B. intention to create legal relationship. Next question. Which jurist has said contract is not joke of leisure time? So the correct answer is C. Lord Stowell. Next question. Which of the following is not a remedy for breach of contract? A. damages, B. injunction, C. fine, D. specific performance. The answer is C. fine. So out of these options, fine is not a remedy for breach of contract. Next question. A patient in a lunatic asylum who is at intervals of sound mind, A. may contract during those intervals, B. cannot contract during those intervals, C. may contract during those intervals with the aid of a guardian, D. may contract after having permission from the competent government authority. So the correct answer is A. may contract during those intervals. Next question. finder of lost goods under Indian Contract Act 1872 is A. Bailor, B. Surety, C. Bailey, D. None of the above. The answer is C. Bailey. Next question. Change of the nature of the obligation in a contract is known as A. Recession, B. Novation, C. Renovation, D. Alteration. The correct answer is B. Novation. Next question. A promise to subscribe to a charity is A. Void contract, B. Void agreement, C. Voidable contract, D. Valid contract. The correct answer is D. Valid contract. A promise to subscribe to a charity is a valid contract. Next question. In which of the following sections the Indian Contract Act embodies the rule in Clayton's case relating to appropriation of payments? A. Section 62, B. Section 59, C. Section 58, D. Section 61. So the correct answer is B. 59. That's it for the today's video. I hope you liked it. Please don't forget to like, share and comment, and also please subscribe to the channel if you haven't subscribed it yet. Thank you so much.